a live Zoom court here. Plus County
I will accept your plea,
Court.
and I will find that it was made knowingly and voluntarily with a full understanding of the consequences. There's a statement here says on April 11th in the city of Lacey, this year, you unlawfully entered the building or entered the parking lot at A230 Martin Way East after you had been trespassed from that location. Is that your statement, or do you adopt that as your statement?
Hold on.
Yeah, I do. But I really thought the year had passed. So the officer was quick to remind me that that I only had 9 days left to the year of trespass was over with, and I would have been cleared to park in that park there again. But only had 9 days left, as the officer stated. So he issued me the ticket.
Damn.
Well, it's a little more than just a ticket, but this is a criminal offense.
Yes, sir.
Okay. All right. I do find that your plea has a factual basis. Did you go over this form yourself or with your attorney?
What's that, sir?
Did you go over this form yourself or did your attorney read it to you? How did that occur?
Well, he read it.
Signed remotely.
He read it to me.
Okay.
Okay. Go to Texas.
Okay, I've accepted the plea. I'll hear from the city first on whether I should follow the recommendation of a deferred sentence.
A deferred
Your Honor,
sentence.
this is an agreement that both parties have come to. I would note that normally the city asks for 2 years probation on a criminal trespass case. I'd note that the city's taken into consideration what the court's already heard from Mr. Pratt, and that he was close to the end of the timeframe from which he was restricted to going to Rite Aid, but he wasn't there yet. This agreement gives him the opportunity to, if he complies with not have any law violations and staying away from the Rite Aid and paying any
from the Rite Aid.
A year from now, the case will be dismissed. So we ask the court to follow this agreement.
Mr. Swenson.
Honor, I ask the court follow the agreed recommendation. As Mr. Pratt indicated, he thought the trespass had expired. It had about a week left. So that's where we're at. I think this is an appropriate resolution given the facts of this case. Mr. Pratt, Your Honor, is in the process of applying for disability benefits. I'd ask the court to waive any legal financial obligations.
Thank you. Mr. Pratt, is there anything you want me to consider before I make a decision as far as what we're doing today?
No, whatever you decide, I'll go with, and it is what it is.
Let's come here.
It was $120 to commence September 25.
I don't know what this court one is, but it's new.
1-year PDA, and that was entered back in July of 2025. We're well past that date. All right, I'm just getting that information to see whether or not it's unreasonable to request to go forward. The allegations are failure to comply with or provide proof of treatment and failure to pay court costs. Mr. Vazquez, do you, what is your response to the request to hold the hearing and move forward with fact finding today?
Oh, I mean, I would just need some time. I mean, it looks like she's been in compliance for several months, and then obviously we're now in the summer, something happened. I need some time to talk to Miss Maeve about that process and how that works. I just haven't had time to do that yet. So if we want to set her to the end of the calendar, happy to try to do that.
Yeah, because I'm
Trying to
seeing
find a
in
video to
compliance
watch here.
February, out of compliance March, in compliance May, and then 3 consecutive months of out of compliance. And we are well beyond the last day of the pretrial diversion agreement. So the city having an interest in resolution. So if you need more time to speak to her, we can make that happen, because I am considering moving forward. So I want to hear either a defense against moving forward, or if there's resolution, what we need to do, or if there's a renewed argument to continue, what the basis for that would be. So Ms. May, please don't leave. We're going to set your matter so that Mr. Vazicek can speak with you a little bit more. The city is asking you to go forward today, and I'm entertaining that motion. I'm entertaining that request. Mr. Mantilla, 3504-24742, JNS motion to revoke.
To revoke? Ooh, damn.
There's 3 files. I think there's 3. All right, so 3504, 35477, 3504, 36587, and 3504, 24742. And a motion to revoke filed in 2 of them because they were in compliance. So there's an existing motion to revoke in the 4-2. Okay. So, good morning, sir. How are you? There has been a new motion to revoke filed in the cases ending in 7-7 and 8-7. Those are both on pretrial diversion agreement. Do you have any questions about your rights?
No.
All right. Mr. Vazicek, are we entering denials in the 7-7 and 8-7 matters?
Yes, Your Honor.
Okay, turning now to the 4-2 matter, which was previously, this was set for today, and there was a prior denial to pretty much the same allegations, and that one's on suspended sentence.
I've never asked for a continuance at first appearance before, but would make that request of the court today.
Yes, sir. So yeah, we'll grant that request, and I'll just let the deputies at the jail
Judge
know
Knight.
once they're able to be on here.
This is Clayton County.
Judge, good morning. I'm actually on the female side. It's the male side that's held up. So I have Miss Collins here. Actually, I have all the females ready.
All right.
Did you want to?
Yeah, if you can bring her on up, and then we'll do the females after while we wait for. All right, Mr.
Thank you.
You're welcome. All right, Ms. Collins, good morning, ma'am. This is Magistrate Court of Clayton County. Judge Knight's here. It's July 13th. And you're here actually on for an extradition matter here, as fugitive from justice warrant, along with the first appearance. Mr. Tom Florio, if you can see him, he's counsel here that your family has hired. Do you see Mr. Florio here?
Yes.
All right, ma'am. And Mr. Florio has asked for a continuance of your matter to see if it can potentially be resolved, or if there's some type of identity fraud situation here. Mr. Florio, if you wanna just chat with her briefly, if you need to, for a moment here.
Good morning, ma'am. Your mom and dad are here, and I understand that you may be the victim of identity fraud. And so we talked to local counsel in Florida, and we're working to try to figure out this warrant. And so I've requested the Honorable Judge Knight to reset us to tomorrow morning's calendar to allow us 24 hours to try to do as much investigation as we can. I'll be to the jail to see you face to face in a little while. I just wanted to obviously let you know this morning that you knew what was happening. And I believe the Honorable Judge Knight has been kind enough to give us that 24-hour period to see if there's any way that we can resolve some of these issues to hopefully move towards your release as quickly as possible.
Thank you so much. I appreciate it.
Yes, ma'am. Thank you, ma'am.
All right, thank you, Mr.
Your Honor,
Florio.
for that.
Yes, sir. Ms. Collins, so you'll be on, you'll remain there, of course, until tomorrow morning. You'll be back on at 11 a.m. And hopefully Mr. Florio your attorney may be able to resolve it before then, but if not, you'll stand by. So that will be all, unless there's any questions from you, Ms. Collings, or you, Mr. Florio.
No, sir, Your Honor. Thank you, Your Honor.
All right, thank you, sir. Ms. Florio, good to see you. Ms. Collings, good luck to you, ma'am. See you next time.
Thank you, Judge.
Thank you.
There you
Your Honor,
go.
that concludes
First
my business before the
appearances
court. May I
right
be excused?
there.
Yes, sir. Good to see you. We'll see you soon.
Good to see you, Your Honor. Thank you.
Thank you. All right, Deputy, what's your name there, ma'am?
Oliver, sir.
Oliver?
Yes, sir.
All right, yes, ma'am. So I'll go ahead and do the females.
All right, ladies, stand up.
We'll be on standby, and Mr. Fry will just be on hold.
Yes, sir.
Back this way. Stand right here. So I'll swear y'all in.
All right, good morning, everyone. Ladies, this is July 13th, 2021's Magistrate Court of Clayton County. Judge Knight's here presiding on the first appearance calendar. This morning, I'm going to inform you of certain things. I'll inform you of what you're charged with, what your your next court appearance, which will be a preliminary hearing date, is. I'll also inform you of your bond amount, if you're entitled to a bond, as well as, most importantly, your constitutional rights that remain with you throughout the proceedings from the time you're arrested all the way through the disposition of your matters. Most importantly, today, I want to let you know you have constitutional rights that never go away. You have the presumption of innocence until the state, which is the district attorney for felonies or the solicitor general for misdemeanors, prove any charge or charges against you beyond a reasonable doubt. That is their burden, and their burden alone. You don't have to present anything if you choose not to. You have the right to an indictment by grand jury for felonies or an accusation for misdemeanors. The indictment is for major felonies, and the district attorney will bring that formal charging document to the grand jurors, which are citizens there in Clayton County, and present your charge or charges to the grand jurors. If they come back with a true bill of indictment, that your case will continue forward. If there's a no bill, then your case can be dismissed at that time, or will be dismissed at that time. For other not as serious felonies and for all misdemeanors, you have the right to an accusation, which again is a charging document, and the district attorney brings it, of course, for felonies, and the solicitor general for misdemeanors. You have the right to a speedy and public trial. You have the right to see, hear, and cross-examine any witnesses that the state can call to testify against you. You have the right to compel the attendance of witnesses on your own behalf through a subpoena, which is a document that you can send or serve someone, and they have to appear to testify before the court. Some of you believe there may be one or two of you who may not get a bond today. That doesn't mean that you'll never get a bond on this matter. It just means that today I cannot give you a bond. Keep in mind that this is the magistrate court, and by law, magistrate court judges cannot give a bond on certain offenses by law. Also, other factors that come into play can be your criminal background or history, as well as the nature of the offenses and other factors such as being a flight risk. Those things can be taken into consideration today. However, you can get a bond at a later date. There's a bond calendar set for September 3rd, 2021. If you don't get a bond today, and again, doesn't mean that you have to wait until September 3rd. It simply means that today there's no bond. At a later date, your attorney can discuss with the district attorney about bond, and you can do before that September 3rd date. Also, if you're posting a bond or there's a bond, you do have bond in this situation here on this charge or these charges, and you go through a bonding company, the bonding company charges a fee, a certain percentage. It could be 15%, it could be less. Please verify with the bonding company.
Clayton County
On what the bonding company's fee would be. So the best person or people to speak with would be someone at the bonding company. Generally, if there's some type of property, there has to be equity in the property of up to 3 times. So for example, if the bond is $1,000, the equity in the property can be up to $3,000. And again, this is general information on bond. Please verify with the bonding company once you speak with a representative. Some of you may have a special condition on bond. Special conditions mean that you cannot contact someone or you cannot go somewhere. If I say don't go to 123 Main Street, you can't go there. Don't contact Joe Smith, you can't contact Joe Smith. If, for example,
Don't contact
someone wants
Mr.
to
Knight.
post your
That means
bond and
don't
that person is the
contact him.
subject of a special condition, you cannot, or that person cannot post your bond at this time. So keep those things in mind, and I will inform you at the appropriate time when I speak with you individually if there's special conditions or not. Failure to comply with special conditions of bond can result in additional criminal charges such as aggravated stalking or influencing a witness or other
Any of that
charges. So keep
kind of
that in
stuff
mind
can
as
lead
well.
you into
Also,
more jail time.
just to let you know, your next court date is your preliminary hearing or probable cause hearing. Prelim, as it's also referred to. The preliminary hearing or probable cause hearing is simply a hearing that will happen where the officer or officers who arrested you may appear, and they will have to inform the judge the valid, the articulable reason. They have to state, why was this arrest made? It has to be a valid legal reason that the court can consider, and if there is a valid
We're
reason
going
and
to
there's probable cause.
Summer County Court.
Do you have any complaints about how he has treated you? Do you have any complaints about how the court or court personnel have treated you? Okay.
God, it's dark as hell.
And to the charge of count 2 felony theft, how do you wish to plead? And the allegations contained in the complaint, which would be the factual basis for this, Mr. Marchinsky, are that on or about the 9th day of July 2026, the defendant did exert unauthorized control over various personal property owned by Lily or David Clark here in Wellington, Kansas, and the value of that personal property was greater than $1,500 but less than $2,500. They were on the property, obviously taking that personal property. Is that the state's factual basis?
It would be, Your Honor. Yes, sir.
And Mr. Dillon, you've had the opportunity to review the state's evidence and see the officer's reports and the victim statements. That you agree that the state has the actual ability to prove that factual basis?
I do, Your Honor.
Okay. Court will find the defendant has knowingly, willingly, and voluntarily waived his rights to a trial, that he has voluntarily entered a plea of guilty. The court will find there's a factual basis for the court to accept that plea, and the court will find the defendant guilty of count 2 felony theft at level 9 non-person felony. State have a motion regarding count 1.
Yes, Your Honor. I would move to dismiss count 1 with prejudice. Thank you.
We'll need to set this matter for a pre-sentence investigation report. Do we need an LSIR? Is this going to be like an SB 123 plus, or?
No, it's not going to be 1, 2, 3 plus.
I mean, it could be any low-level 789 felony could possibly potentially trigger that. I don't think we had contemplated it as being an outcome here, but it is within the legal realm of possibility that it could qualify.
I think it may be best precautions to go ahead and order that evaluation to see if Mr. Daniels needs that additional help on probation. So we're talking about probably 6 weeks.
Okay. We can
maybe October
6 weeks.
October 15th.
That'll work.
October 15th work. Court will set this matter, or we'll order a PSI at LSIR. We'll set this matter for sentencing on October 15th, 2026 at 11 a.m. Is the defendant on bond?
Yes.
Court will modify the defendant's bond. Mr. Daniels, I'm going to modify your bond to require you to make and keep all your appointments with court services and any other service providers that need to be handled to get the PSI and the LSIR done. Do you understand that? Fail to do that and your bond could be revoked and you'd sit in custody until those things could be done. So it's kind of important that you do those things. You'll need to go downstairs immediately and report to court services to set up times to do those things. All right. Is there anything further I need to address?
No, Your Honor.
Not on behalf of the state, sir.
All right. This hearing is concluded. Thank you, Mr. Daniels, for appearing today.
Thank you.
is Judge Mott. Mr. Favre, Judge, you've got one with Judge Mott. Is that a formal, you're gonna be, I'm gonna take a break and let Judge Mott handle his case with you first. I think that's Mr. Farrington. Is that correct? Mr. Farrington, if you'll come to the table and I'll step out while this.
Was Judge Merchant, Judge DeJarnett, but that's fine.
Okay. Thought Judge Mott was on.
All right, take this up real quick. It's an arraignment. 26 CR 124 State versus Tanner Farrington. Party state appearances, please.
May it please the court, Your Honor, Larry Marchinsky on behalf of the state.
Mr. Farrington appears with counsel Joseph Favre.
All right, are we ready for arraignment today?
We can proceed with the arraignment.
More
Judge. Mr. Farrington will
arraignments.
enter a not guilty plea, and we'll ask this be set for a status hearing. I think we will have a plea. We discussed it. Mr. Farrington would like one, but Mr. Marchinsky and I just need to hammer out some details.
Okay. Very well. Mr. Farrington, you've been provided a copy of the complaint.
Yes, sir.
Okay. Can you hear me okay?
Yes, sir.
All right. Do you understand what you're charged with in the complaint?
Yes, sir.
All right. To the charge made in count 1, aggravated assault on law enforcement officer with a deadly weapon, level 6 person felony. How do you plead?
But definitely the child support.
Thank you, Your Honor. First of all, and I don't, in
This
my
is
review of Mr.
Texas.
Muse's exhibits, I didn't have any objections regarding admissibility. Mr. Muse, did you have any on mine?
I think it's really just the objection to not proceeding via consent on the issue we already raised on the summary of requested relief. And then I do have some concerns just about lack of personal knowledge on some of the summaries that were created. I think mostly
Golly.
This was a little bit of a difficult exhibit to just kind of read through the way it was formatted, but I don't know what the basis of this information is. If it was just pulled from my client's summary, that's one thing, but those are the only 2 objections I had.
Okay, so what the court will do is grant the court will admit moms 1 through 11.
And may have been intoxicated. You knew what you did was wrong. Is that correct?
That is correct.
All right. All right. It does appear to me that Mr. Bunker has given me a proper factual basis as to
This is Michigan.
that either counsel had aware of any other promises, threats, or inducements not stated on the record for this offense.
No, Your Honor.
None, Your Honor.
Both counsel believe I've
Swear or affirm statements or testimony will give in this matter not pending before the court shall be the truth, the whole truth, nothing but the truth shall be done.
Yes.
Got a
All
jury
right,
trial
so we're ready to begin, Deputy Howell. Stand by.
going on in District 4 in Dust County, Washington.
Let's see, Miss Collins is already gone, so the next up is gonna be you, ma'am. Then you're gonna be next, is that right?
All right, good morning. What's your name?
Good morning, Yvonne DeSola.
All right, Mr. Sola, ma'am, you have 1 count of violation of the Georgia Controlled Substances Act. And that is possession of THC oil. It's a felony. It's 2,000 is your bond, and possession of a drug-related object, misdemeanor, 500. 2,500 is your total, ma'am. And your preliminary hearing is August 31st. That is at 8:30. And
August 31st is
if you
next
qualify for
Monday.
court-appointed attorney, I will appoint one to represent you, ma'am. Do you have any questions?
Not that no. Well, I do, so what would I have to pay to get out, the 2,500?
Yes, ma'am, and there'll be fees applied to that, so it'll be more than 2,500. So once you, well, 2,500 is your total, there'll be fees, a percentage there, and whatever fees that the bonding company, so
2,500.
check with the bonding company, ma'am. I
bond
don't want
out.
to tell you a number because I don't know.
Okay.
All right, any other questions?
No, thank you.
All right, thank you.
Thank you.
Yes, ma'am, what's your name?
Ashanti Harris.
All right, Ms. Harris, good morning to you. You have one count of theft of services, and that is a misdemeanor. Your bond is
Theft.
2,000, and there's a special condition, ma'am. You can't go back to 6406 Highway 85, Riverdale. And that is the K Connery Tax Service. You have a preliminary hearing scheduled for August 30th, and that is at 8:30. And Ms. Harris, I am appointing an attorney to represent you. Do you have any questions?
No, sir.
All right, thank you, ma'am.
Judge Sedgwick is live. We're gonna finish off
Yes,
with
ma'am.
him.
What's your name? Good morning. What's your name, ma'am?
Ada Johnson.
Layla Johnson.
Johnson is your last name? One moment. All right, Ms. Johnson, sorry about that here. Your paperwork slipped away from me. All right, you have a theft of services charge, misdemeanor. 2,000 is your bond. Special condition, you cannot go back to
2,000.
Taps Bar and Grill at 10395
Taps Bar and Grill
Sarah
theft.
Boulevard, Jonesboro. Ma'am, you understand what you're charged with, the bond for special
Damn.
condition? All right, your preliminary hearing is the 30th of August at 8:30. And I am appointing an attorney to represent you. I just wanted to confirm, is that 645 is the first three of your phone number?
Yes, sir. 406-45-4227.
We are finishing up with Judge Sedgwick. Golly.
Turn the camera on, everybody take a seat. Courtroom going live, now we're bringing you the heat. From the judge to the jury, everybody's on screen. We're from the Live Zoom court, you know what I mean.
Yeah. 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 Yelma Municipal Court is live.
But the courtroom's online, judge on the screen, and the case is in line. From Texas to the world, we're watching it unfold. Every single hearing got a story to be told. Click that link, microphone on mute. Everybody watching, trying to figure out the truth. Gavel hits hard, chat start going crazy. Courtroom gets quiet when the judge says maybe. Live Zoom court, everybody tune in from the courthouse screen. Let the proceedings begin. Judge on camera, gavel coming down. Case is going live from every side of town. Live Zoom court, from the country to the city. Real courtroom moments and the chat gets gritty. Turn that volume up, let the whole world see. Live Zoom court, streaming justice digitally. Red light flashing, yeah, we're live on the scene. No courthouse hallway, just a computer screen. Attorney speaking, defendant standing by. Judge looks serious, everybody asking why. Country road, city streets, different courtroom doors. But when that gavel hits, everybody wants more. No